వెల్కమ్ టు లా ఎక్సలెన్స్ డైలీ కరెంట్ అఫైర్స్ సెషన్ కి స్వాగతం. ఈ సెషన్ లో మనం ఫ్యూ ఇంపార్టెంట్ టాపిక్స్ నేర్చుకుందాం. జన్ విశ్వాస్ అమెండ్మెంట్ బిల్. Here, Jan Vishwas Amendment Bill was introduced, and we are going to learn this under the GS paper 2. Recently, the Union government they have tabled this Jan Vishwas or Jan Vishwas Amendment of Provisions Bill in 2022 in Parliament. So the objective is to decriminalize 183 offenses across 42 legislations, and they want to enhance the ease of living and doing business in India. So some acts that are amended by the bill include the Indian Post Office Act 1898, and next the Environment Protection Act 1986, Public Liability Insurance Act 1991, and the Information Technology Act 2000. So these are the bills which are there, some acts that are amended by the bill. Let's see the highlights of the bill. First one is the decriminalizing offenses. Under the bill, several offenses with an imprisonment term of in certain acts they have been decriminalized by imposing only a monetary penalty. So if we see as an example, Agricultural Produce Grading Marketing Act. Agricultural Produce Grading and Marketing Act 1937. So it is counterfeiting grade designation marks is punishable with imprisonment up to 3 years and fine of rupees 5,000 Indian rupees. So grade designation mark indicates the quantity of the article under the 1937 Act. So the bill replaces this with a penalty of 8 lakh rupees. Penalty of 8 lakh rupees under the Information Technology Act 2000. Disclosing personal information in breach of a lawful contract is punishable with imprisonment up to 3 years and fine up to 5 lakh rupees, or both sometimes. So bill replaces this with a penalty of 25 lakhs of rupees. In certain acts, these offenses they have been criminalized by imposing the penalty instead of a fine. So for instances, under the Patents Act 1970, they have Patents Act. A person is selling a falsely represented article as patented in India is subjected to a fine up to 1 lakh rupees. The bill replaces the fine with a penalty which may be up to 10 lakhs of rupees. So, in case of a continuing claim, there shall be an additional penalty of 1,000 rupees per day. Additional penalty. And now let's look into revision of fines and penalties. The bill it increases the fines and various penalties for various offenses which are specified in this act. So further, these fines and penalties will be increased by 10% in the minimum years or minimum amount every 3 years. So appointment of adjudicating officers. As per the bill, the central government may appoint one or more adjudicating officers for the purpose of this determining penalties. Determining these penalties, the adjudicating officers may summon individuals for evidence and conduct inquiries of respected acts. And this bill is also specifies the appellate mechanisms for any person aggrieved by or the order passed by an adjudicating officer. For instance, in Environment Protection Act 1986, it appeals may be filed with the National Green Tribunal within 60 days or from the order. So, why this bill has been introduced to rise in the criminal cases is also a reason. For decades, Scholars of the law have been concerned that criminal law has grown unprincipledly. As per the National Judicial Data Grid, 4.3 crore pending cases are there. Nearly 3.2 crores of cases are in relation to the criminal proceedings. What are the political motives of this act or the bill which they have introduced? First one is political motives. In political motives, as they have opposed to punish the wrongful conduct, and criminalization often becomes a tool for the governments to project a strong image. So governments offer little in the way of justifications to support such decisions. So this phenomena has termed as over criminalization by scholars. Next reason is overcrowding of prisons. We can see overcrowding of prisons, the area where the prison is located and the people who are living in the prisons are increasing. So, as per the National Criminal Records Bureau, the prison statistics belongs to 2021, a total of 5.54 lakhs of prisoners were confined in the prisons against the capacity of 4.25 lakhs. 4.25 lakhs ఉండాల్సినటువంటి prisons లో వీళ్ళు ఏం చేస్తున్నారు అని అంటే ఇప్పుడు వరకు 5.54 lakhs ఆఫ్ ప్రిజనర్స్ ని ఉంచడం జరిగింది. దాని కెపాసిటీ అయితే ముందు 4.25 lakhs కానీ తర్వాత 5.54 lakhs మందిని ఆ ప్రిజన్స్ లో సర్దడం జరిగింది అనమాట. సో లెట్స్ లుక్ ఇన్ టు ద స్కోప్ ఆఫ్ ద బిల్. వాట్ ఈస్ ద స్కోప్ ఆఫ్ ద బిల్? సో ద బిల్ మైట్ అండర్టేక్స్ ద quasi decriminalization. So observer research foundations, they have reported jailed for doing business found in therefore more than 26,134 imprisonment clauses in a total of 843 economic legislations and the rules and regulations which seek to regulate the businesses and the economic activities in India. So, in this case, the number of offences deregulated under this bill seems to be a mere drop in India's regulatory framework. So, the regulatory offences to be considered for this decriminalization needed to be prioritized not only from the point of view of the ease of doing business but also from the point of view of ills that plague our criminal justice and system itself. So, the bill confirms that understanding of this government that the decriminalization should be limited for the regulatory domains. They should be confined for the regulatory domains.